and we rapid speed down to 2,500.
Good point, wherever you reduce speed to 180.
Blackbox.
Hey everyone, welcome back. KP's Blackbox. Today I am flying solo, and main reason is that I want to specifically talk to you at home about estate planning. Now, most people hear that word and they're like, "Oh, estate planning, that's for the wealthy. It's only for those who have, millions of dollars of assets." And I'm here to dispel that myth that that's just absolutely not true. If you're 18 years old, you now have an estate. It could be the clothes on your back. It could be anything that anyone has gifted you. And most people don't like to think about their estate because the estate usually signifies that there's an end state, death. Well, that's part of it. But there have been many people who have had living deaths, and there's been a lot of issues in terms of a person who's incapacitated is not able to make decisions on their own. So they need someone else to make those decisions for them. And if there's no will, that happens only upon death. So the only way to truly have someone represent you is through trust or through power of attorney. And so we're going to talk through today why estate planning matters, even if you're as young as 18 years old. So estate planning really is about control, clarity, and care. It's just not simply about wealth. And so I want to state that today, and that be really the framework for what we're going to talk through. And I'm going to share with you some stats as Americans in general, kind of where we are in the scope of estate planning. And then I'm going to also talk a little bit about some wealthy people and wealthy people who unfortunately passed or were incapacitated without any estate planning. And that's referred to as dying intestate. And so really exciting podcast today. I'm going to try to make this as interesting as possible, but I think it's one of those that sometimes we miss the mark on paying attention to things that are just boring. And just because something is boring doesn't mean it's not important to you. And estate planning is one of the most important things that you can manage over your entire lifetime, not only for you, but for those that you love and that you care about. And what really kind of spawned this for me is that over the last few years of interviewing consumers, I found something that was happening and something that was just resonating with me was that more often than not, every person that walked through my door had an estate, but did not have an estate plan that was managed properly. Or for, I would say, probably close to 70% of the folks that walk through the door, even with assets, there was not even an executed will nor a trust. And so when I started seeing that over and over and over again, and it really came to fruition for me and what we're going to share with you today, that we created a platform and a source, estate planning, in the form of software as a service. So I'm going to be sharing that with you today. And then also at a point where you can't do it yourself, well, then there's times where you're going to have to engage legal counsel. And so I want you to be prepared to know that when the attorney starts using certain types of words, that you don't feel a little awkward sitting there going, well, I don't know what a trustee is, or I don't know what a grantor or a creator, or what does he mean by beneficiary or guardians. So we're going to peel the onion back today and talk through all of this. As always, before we start our podcast, something that we've done for years now is being able to pay tribute and honor to our veterans. Me being a prior Marine, and being on a few deployments and having to leave family and the sacrifices that are made, not only for those that are forward deployed, but those military members that are in the rear with the gear, your spouses, your children, and your extended family. I think it's important to salute and pay homage to those folks. And then probably more importantly are those who have made the ultimate sacrifice and given their life for their country voluntarily or even involuntarily through accident. The military is a dangerous place. You know, folks take for granted when they send their spouses off to work each day that they're just going and doing maybe some desk job or maybe some, boiler tech or IT tech. But sometimes they got to go train, and battlefield training at whatever level you're doing at has an element of risk to it. And so even in training instances, people lose their lives or get mortally wounded. And I think it's always important to say thanks to those. We still have a 100% volunteer service. And to me, if we can keep that in place in our country, that's awesome. And it's a great feeling to know that we still have a large number of patriots who are willing to go out there and make a sacrifice for their community. And I know, look, sometimes people do it because they feel like they have no other choice. But they're still going to serve, and in exchange for that service, they're going to be pretty well taken care of. And those of you that are socialists out there, if you're really in love with the idea of socialism, I would tell you the greatest experiment ever in socialism is serving in the military. So if you want to feel what it feels like to be a socialist, spend a few years, especially those early years when you're at a low enlisted rank, and you'll start to understand how socialism works. So not to get all political on you today, but I think it's really important in our country to really, when you see a veteran or you see an active duty person, I think it's your civil duty, personally, to say thanks. And that could be military, that could be a cop, could be Coast Guard, and, even the folks in the Peace Corps. If they're serving, stop for a minute and say thank you, because it does matter. So to all of my veterans out there, to all of my active duty friends, family, associates, we love you. We thank you for your service. Cheers to you. And by the way, that toast has been brought to you by, in this part of our podcast, we've been sponsored with Four Branches Bourbon. One of my friends, the great Harold Underdown, is one of the founders of Four Branches Bourbon. And every guest we've had on the show, every veteran that's been in my office that I remember to do this, and I don't often, sometimes I just goon it and forget, but I try to get every veteran to sign our Four Branches plaque here, and we do our event this summer. We're going to give this away, auction it off in charity with a bottle of signed bourbon by the founders of Four Branches, which are all vets. And it's important, again, to say thanks and give back. And so I really appreciate Four Branches Bourbon for giving us a bottle to toast. And the reason I toast Four Branches is simply this. I had Harold Underdown on the show. I think it was last May, right, guys? I think it was May. And we had him on the show. We did a blind taste test because I'm like, man, if you're going to promote your bourbon, I want to know that you know the taste of your bourbon. So we kind of did like the Coca-Cola, Pepsi-Cola taste test. And Jacob, my son, in the back studio there in the room making all the magic happen, he and Cody, he switched it up and put one of the taste samplings as a scotch. The other three were bourbons. And I don't remember. I think we had Four Branches. But was it Buffalo Trace? Do you remember what we did, Jake?
I think it was Four Branches, Buffalo Trace, Angel's Envy, Zerai, and then Oh no, whatever.
and whatever scotch we had.
Macallan or something like that.
Yeah. So right off the bat, Harold got the scotch. I mean, peaty. If you're a bourbon drinker, you know scotch is not bourbon, not even close. Excuse me. And then he not only got which bourbon was which, but he picked 4 branches. And I thought that was pretty cool. I was like, okay, if you get this right, we're going to promote 4 branches on every podcast, every Blackbox podcast for the next year. So through May, 4 branches, you got us saluting you guys and what you do for vets in your brand. So thanks again, Harold. Shout out to you and the 4 branches guys. So, all right. Estate planning, why it matters. Again, it's about control, clarity, and the care that you have not only for yourself, but for those that are left behind, either through your death or incapacitation. So let's start with the basics. Every person, in my opinion, if you're over the age of 18 years old, at a minimum, you should have a will. And a will is basically a legal document that interjects into your estate after your death, and it directs how the assets are going to be distributed and who's going to handle your final affairs. So who's the people in a will? So when you start with a will and you craft this will, there's really going to be 4 people involved, or 4 managers or beneficiaries. So the first one's going to be the testor. So the testor is the person who creates a will. That's more than likely you the consumer, you the listener. You're the testor. So you're the one who creates the will document, or says what you want to have happen in this will document. So all of the guts, the contents of the will is your wishes. Then you got to have somebody carry that out and carry those wishes out for you. That's going to be the executor. So the executor carries out the will, handles probate, pays any of your last debts, and then distributes your final assets. Now, a lot of you may be thinking, well, Kenny, I don't have 2 dimes to rub together at this point, but you still have an estate. If you own anything, you have an estate. So after 18, most laws and most states say that you are a responsible, legal human being, responsible. You're no longer a minor. You're an adult at the young age of 18. And then there's kind of another rule that, most states will look at as age 21. That's when you can drink beer, have alcohol, and not have to sneak it, Cody. You remember those days? He's pleading the fifth back there, not saying anything. But the executor is the person who's going to carry out your wishes. The testor is the person who creates it, you. Then, well, who do you want your stuff to go to? Who do you want your socks, shoes, money, IRAs, 401ks? And if you're a young 18-year-old, all the way up to you're a 90-year-old, you're probably building an estate. If you have your job, your first job, more than likely in the United States today, most large employers have a retirement plan, like a 401k. And they may be putting 4%, which is what's called a safe harbor contribution, into your retirement plan for you. And if you're not aware of that, that's something you should go back and ask your employer, hey, do you have a retirement plan? Are you contributing? Are you matching? Or are you making a gift or a contribution to my retirement plan? So if that happens, then you have assets. And those assets are sitting inside what's called a qualified account, like a 401k, IRA. Those assets need to have a beneficiary. So that's the third person in this grouping. So we got testor, we got executor, now beneficiary. The beneficiary is who do you want your stuff, your money, your assets to go to? And if you don't name them, and if you don't pick who that's going to be, whatever state that you're domiciled in, whatever state that you have residence, that state is going to decide for you, if you do not have a will, who's going to get your stuff. And it may not be the person or persons that you would want that to go to, or even maybe the charity that you want it to go to, or your church. So it's important at a very young age, make sure you have at least a will. I'm going to talk to you today about doing a living will. Well, a living will is basically a document that's like a will that's kind of supercharged. So I'll start telling you a little bit about that as we get through the podcast today. There's a fourth person involved in a will, and that's going to be called a guardian. So if you, by chance, start having children, and you have children at a young age, it's going to be important that you assign a guardian to your minor children. Any child under the age of 18 is considered a minor. So if you have a minor child and you do not have a will, well, here's the scary bad news. Basically, Child Protective Services are going to come into play, not in an egregious manner or a hateful manner, but the state now says, hey, we're going to assign this agency to make sure that this child has the best person take care of them since the parent's no longer there. So if you do not have a will, you die intestate. Technically, if you don't act quickly or your family members don't act quickly, those children could go into temporary foster care, meaning another human being that they do not know could be in charge of their care because the court and the state has basically vetted these foster parents to be the best person to take care of your child in the event of your death, because you didn't do the things properly to assure that that doesn't happen. You see, basically this will is your last document of what you wanted to have happen that's been notarized and witnessed, meaning you need to have a notary sign that document. So if you write a will out and you just do it in your own John Hancock writing, or, hey, do you guys still know about cursive writing? Cody, Jacob, can y'all write in cursive? They're millennials, so.
I can barely write in print, so.
Okay.
But yes, I can write in cursive.
What's Cody saying? Can he write in cursive?
Cody writes in cursive.
He writes in cursive.
Yeah.
Go figure, Cody. You're in touch with your feminine side there.
I do have a quick question.
Go ahead.
I remember hearing about I don't know how true it is, but there's a popular story of a guy on a farm getting crushed by his tractor, and he wrote out his will. He knew he was going to die in the middle of nowhere. Wrote out his will in blood on the side of the tractor. Is that a liable will? Does that pass as a will?
So like a viable will,
Or a viable
you mean?
will,
Yeah. It's a great question. I'm not an attorney, so I can't give legal advice. I'll give you my opinion. I would say that would be not a legal last wish. It is apparently his last wishes, but courts look at that through a lens, from my understanding, that if it's not been notarized and it's not been witnessed, it could be contested. So this is what happens in a lot of estates, and we're going to talk about one specifically today, real life, very wealthy person. You've probably heard of her, Aretha Franklin. So Motown, big voice, beautiful voice, great songs she wrote. But she had multiple wills that were just stuffed in her couch and chairs, furniture. And it was very confusing for, what was her true intent? Because not every document she wrote on said the same thing. So the problem would be, Jake, is that if this farmer wrote his last will and testament in blood on the side of a tractor, that's a pretty wild story. Is that like a fable, or did that really happen?
I'm not sure. I can look it up real quick.
Yeah, well, let's see if we can find the Google and fact check ourselves and see if that was a real story. That'd be pretty interesting to talk about. But my guess would be that the court system would look at that, and then what they would basically do in the intestate process, him dying without a will, and they look at what is on the side of this tractor in his last wishes, if family members who were his rightful inheritors of his estate, and the court gets to decide that, and it's usually going to follow a bloodline, like who is his next of kin. Whoever his next of kin was is probably, in my guess, and there's going to be some legal chatter around this, and I would love any attorneys watching to, if you want to comment in our comment section, to set the facts straight here. Since I'm not a lawyer, I didn't go to law school, I don't know the answer to that.
So it wasn't completely accurate. It wasn't in blood. He did it in a pocket knife, but it supposedly was honored by the courts. He wrote down, "In case I die in this mess, I leave all to the wife."
So
and they honored it.
So it was very specific. He didn't make it complicated. He left it to one person. But hey, folks, there's an example right there. So that really happened. His name was Cecil George Harris. Scratched a valid 16-word holographic will into his tractor fender with a pocket knife pinned under it for 10 hours. Man. Whew. He says, "In case I die in this mess, I leave all to the wife." Don't you love when dudes refer to their spouse as the wife? Well, hopefully he wasn't Mormon. Not bad joke. But he left this to his wife. And let's see some key facts. Knowing his situation was dire, he used his pocket knife to scratch wishes into the tractor. "In case I die, leave it to the wife." George, or Cecil G.O. Harris. Despite not being a traditional paper document, the court recognized it as valid holographic will, a handwritten document, valid in some jurisdictions without witnesses. That's key. So I think that would be the answer, Jake. So we're residents of Virginia. Virginia wants you to have witnesses for your will. Now, if you die intestate or without will, without a testament of what you want to have happen that's been notarized and witnessed, then in Virginia, you die intestate, and they're going to look at extenuating circumstances, the court systems, to make sure that the right legal person next in line, because you didn't tell them who, so they're just going to go to who's next in line, making sure that they get what they deserve. Now, a will and intestate will, meaning the state's will, both of those can be contested by family members. So let's just make sure you understand this. Wills and without a will, both of those estates can be contested. So even though you may have a legally binding will that has a testor, an executor, a beneficiary, maybe guardians for minor children, you do all of that right, and you get it witnessed, and you get it notarized, and you put it in your safe or some safe place, you pass away, you could have kids still fight over what they thought dad meant in his will or what mom meant in her will. And each individual, if you're married, needs to have at least a will. And I'm going to suggest that you have at least a living will, which would include medical directives, medical power of attorneys, and general power of attorney, or specific power of attorney for how you want your assets to be utilized beyond what's being defined in the will. So you got this will, you pass away, and family members now start fighting. The court will allow people to contest what's in the will. But let me give you the bottom line here. When you have a will and it's contested, the only ones who are going to win will be your attorneys or your opposing counsel attorneys. So when family members start fighting, I've never seen that end well. There was a big real estate mogul here in Virginia Beach who owned one of the largest real estate brokerage firms. He had a wife, had a mistress, left the wife, left a portion of the estate to the mistress, a portion of the estate to the wife. The long story short, one of my buddies who's an attorney who represented the the mistress. It ended up in about a 4-year legal battle. And the long story short was the attorneys ended up with more money than those who ended up in the estate because they were spending the estate's money to fight each other. And it was unfortunate because there was just so much ambiguous language that both of them was like, well, who's who in the zoo? So that's a key factor if you're working with your legal counsel or you're working in a DIY system where you're creating your own trust or will. Don't be ambiguous. Be as clear and concise as possible, regardless of whether you have a will or you're utilizing a trust. So wills matter specifically because it names guardians for any minor children. It provides your loved ones and those left behind legal direction of what you want to have happen. And then it prevents the state intestacy rules from taking over and managing your estate for you. So there's the basics of a will. My position is, and if I were talking to you one-on-one as a individual client, I would say number one, if you're going to have a DIY platform like we use for our clients, we use Blackbox Pro. Guys, bring that up for me if you can on the screen here. Blackbox Pro is a software that I created with developers and attorneys to help our clients develop an estate plan. Now, we don't do this for free. We sell the software as a service and straightforward pricing. You can have a will for $1,995, will and trust, I should say. But before you go spend $1,995, we actually take you through a will or trust quiz. Which one's right for you? Which one should you have? So you'd simply click on that Take Our Quiz button. And then what it's going to do is take you through your name, your rank. Guys, can you just put that in there and put some info in? And so phone number, email, and we want this because we're going to need to know how to contact you if you want to be contacted. If you don't want to be contacted, we're not going to bother you. But you put this info in, you say okay, and then it's going to ask you some very basic questions. So, let's say 50 years old. Are you married? Say you're married. I have children. Let's say you have children under 18. And let's say, okay. What assets do you own? Well, you got investment accounts. You've got real estate. You've got, let's say you have some outside of your home state. Maybe you own a business too. All right. And then we'll say, okay. So what type of business? Let's say it's a corporation. So what's the value of your assets? Let's say between $1 million to $5 million. How do you own most of your assets? Let's say jointly, since you have a spouse. And then which documents do you already have? If you're not sure, just say none. And then what are your priorities and goals? So let's read this. What is most important in your life? A good estate plan will be built around these priorities. And don't worry, you're always able to change your mind. So once you start an estate plan, folks, you can change your mind. You can change what you have in a document if it's revocable. And we'll spend a little bit of time on that today. So revocable living trust. So what type of trust are we going to use? The basic of what I say every American who has any assets whatsoever, we should graduate from a living will to a revocable living trust. And this is basically what this is going to take you through. So go ahead and continue on with the quiz here. So the last will and testament's a public record, can be read by anyone for any reason. It's not private. For some people, this is a good reason to get a revocable living trust. So as you're going through this quiz, how important is privacy to you? Let's say everybody likes being private. So I would say for most people, it probably is a 5. So this is basically saying to you that a probate process, if your estate goes through probate because you only have a will or you passed intestate, it might take you 12 to 24 months for your family to work out the kinks. So continue there. So how quickly is speed? Let's say, yeah, that's important to us. We want to get the estate liquidated and disposed to who it's going to go to. So 40% of families report internal conflict when they're settling an estate. We're going to talk more about that in just a few minutes. So conflict, let's just say that's a 3. We feel like, oh, everybody's going to get along. Your last will and testament require a lengthy process. We've already talked about that, so we'll continue. How important is it for you to maximize or minimize your loved one's effort in settling your estate? I would think all of us that would be a 5. Do any of these situations apply to you? Are you pending a divorce? That's in and of itself is a big estate move. Any children that you're estranged from, any adult dependents. So let's say, I have a daughter who's disabled, so I say, yes, I have so select C for me, Jake. I don't have a prenup. Cat's like, thank God, jerk. But no prenup. I have children with multiple partners, doesn't apply to me. Non-U.S. citizen in the estate plan. Let's say F. Yeah, let's say we've got a family member who's not a citizen. What would we do with that? Okay. So this is where we're going to tell you, based on the way you answer these questions, we would say at a minimum, you should have a revocable living trust. It's that easy, folks, to work through this quiz to find out what's important to you and what you should have. So let's go to the trust concept now. Why own a trust and what is a trust? So trust is basically a legal arrangement that holds the assets of the owners or beneficiary for the benefit of beneficiaries and can work during your lifetime and after you passed. So let's talk about now, so you've got this trust, you've got this legal document. It sits on top of your will, if you think about it and how it stacks. So the trust is going to have basically some parties involved in it. So who makes up the trust? So the trust is made up of by grantors or settlers. So that's fancy legal words for those who create and fund the trust. So you could have a grantor, that's usually a person who's putting assets or money into the trust. The settler is basically the person who's either created the trust and, theoretically could be both and putting money into your trust. Then there's this person called the trustee. The trustee is simply the person or persons who manages your trust. So they're going to manage whatever money and assets you've put into that trust and that has legally had its name changed to the trust. Here's an example of that. Let's say you have a piece of real estate, and your real estate, like it's your primary residence, it might be owned by you and your spouse, or it may just be owned by you personally. So if you own a piece of real estate, I'd say, number one, that's the first key factor for me to say, you should probably just go ahead and graduate to a revocable living trust. And it's because you own assets. And when you own this asset, you want to be able to transfer those assets to the next generation without the government, state, federal, or local being involved in that. But if you like the federal government being involved in your business, then have a will or just don't have a will. And intestate, I guarantee you they're going to take over. So you've got a grantor settler, that's the ones who starts or sets up the trust. Then you're going to have a trustee, that's the one who's going to manage or control the trust. Usually if you have a revocable living trust, the grantor settler, those people are usually the same as the trustee. Where it changes is when you become incapacitated as a trustee, or you pass away as the trustee, who's AKA also the grantor settler in 99% of revocable living trust cases. So you have to have a successor trustee. You have to have number 2, who's the VP? Who's going to come in and take over if I pass away or if I'm incapacitated? Now, if you have a will, here's the distinct difference between control in a will and control in a trust. In a will, if you become incapacitated, you're in a comatose state, and you can't make decisions for you or your family, the will does nothing for you. That's where medical directives, medical power of attorneys, and certain types of powers of attorney, I would say limited to start out with, can come in and help. But the trust is going to be the most powerful tool that if you become incapacitated or have a living death, it's important that that trust be in place, at least a revocable living trust. And then that successor trustee has the power now upon your incapacitation and or death to step in and carry out the wishes that you outlined in that document called a living trust. Now, let's run through a couple scenarios here. Let's say you're incapacitated. Successor trustee who might be a spouse, might be a family member, son or daughter, or trusted member of your family. They step in and they act on your behalf. Well, how are they going to know how to act? That legal document called the trust is their outline. It's their, think of it this way, it's their operating agreement that outlines for them, based off the wishes that you, maybe your spouse, wrote out with the help of software or a legal counselor, licensed attorney. That trust is going to help that person understand your wishes. So now maybe you're understanding why I said earlier, please do not be ambiguous. If you make things really fluffy and, oh, you guys can do whatever you want, I really don't care, that's well and fine, but now you're going to leave that successor trustee to act in your estate's behalf, and they're going to be able to make whatever decisions they want to because you didn't leave them specific decisions or specific decision points to act on. Like in goal planning, I talk all the time about you have to be specific, you have to measure it, it has to be attainable, realistic, time sensitive. Those type attributes should also be in your trust. You want things to happen in a certain way over a certain period of time, and you probably shouldn't drag things out for long periods of time. At some point in time, you want the trust to be funded to whoever you want the assets and money to go to. And there are other little tips and techniques we'll talk through by the end of this podcast. But the trust in and of itself, grantor, settlor, trustee, successor trustee, and then the fourth person or thing involved is the beneficiary. So the beneficiary is who's going to receive the benefits of the trust. Now, if it's revocable, you can be the grantor, you can be the trustee, and you can also be your own beneficiary of your own trust. And that trustee-grantor relationship is what makes it revocable. If they're basically the same people, then you can revoke and change your mind. There's another type of trust called an irrevocable trust. An irrevocable could branch out into multiple different types of trusts, but we're just going to keep it for simple sake today. Will, living will, revocable living trust, irrevocable trust. An irrevocable trust has these same parties: grantor, trustee, successor trustee, beneficiary. But the grantor could be someone who puts money into the trust. So remember that you may have the assets, but you want to segregate your estate. When you segregate the estate, then the grantor, settlor may be different. The trustee, more than likely, is not going to be you if it's your assets, because you want to basically have a hands-off that you may have put the assets in, but you're not controlling them any longer. The trustee controls those assets. So that's where you want to think about the difference between revocable and irrevocable, is who's in charge, who's controlling the assets or the money. Well, why is it important to have a trust versus just a will? Number one, if a properly funded, and when I say funding, it means the assets that you owned previously in your own name are now retitled and managed and owned by your revocable living trust. If you do not fund the trust, you've got a document, and the only thing that's going to work is the will upon your death. If you're incapacitated and you have a living death and you didn't fund your trust, meaning you didn't change ownership into, and you didn't put the assets into the trust through ownership change, you just got a fancy document and an unfunded trust that's now going to have to go through probate anyway to get it into the trust. And that's why a lot of attorneys, and the way we draft our wills through our platform, is we do what's called a pour-over will. So a pour-over will goes, oh, crap, Kenny, you forgot to put this investment account into your trust. The pour-over will says, hey, before you probate it, go ahead and rename it because that was an accident. Kenny actually meant to change the ownership to the trust before he died or before he was incapacitated. So the trust document, the will document says, execute putting it into the trust, and here's the legal document to say that. Sometimes you can get pushback from institutions, so you have to show them the documents. You have to show them more than your certificate of trust, that your language, think of it again as operating agreement, what you want to have happen, that black and white document is going to say, pour it into the trust. But the number one reason trust matters is that we can avoid probate. You can maintain privacy. This is huge. So if you want to keep your estate private, fund all of your assets into the trust. We'll talk about qualified assets like IRAs, 401ks in a separate conversation here in a few minutes. But it's important that if it's titled into the trust, then the court doesn't release that trust document and who to contact and who's who in the zoo. So you have a private estate. Control of the timing, conditions of inheritance, huge for a revocable living trust. You inside this trust are instructing the successor trustee when you want these assets to be dispersed and how you want them dispersed. And then incapacity, that's a huge one. Most people always just think of death, but what if you have a living death? How is your estate going to be managed? Best way to do it, revocable living trust. So, quick comparison. Wills are simple, low cost, typically. Probate is required, and your assets are public. A trust, much more control, avoids probate. They're private and flexible. What they're not, a revocable living trust does not avoid income tax. There's some stuff out there on the internet where people are talking about, hey, set up this trust and we're going to avoid income tax with this revocable trust. BS, run. It's scam alert number one. There is no way to avoid income tax using a trust. In a manner of how irrevocable trusts get used, they can avoid estate tax. And so effectively, if you have an estate right now, 2026, over 13.6 million, then anything over that estate, we now got to start worrying about estate tax. That's separate than income tax. But if you have an estate and you and your spouse have an estate below 26.5 million, 26.7 million in 2026, there's no estate tax for you. Really no thing to worry about other than making sure your estate gets funded properly and that the assets get dispersed to who you want them to go to, minimizing a form of tax, which probate is a form of tax, but it's not income tax. So trusts, revocable trusts specifically, aren't designed to avoid income tax. There are other certain types of trusts that we don't have the time to get into today that can avoid estate tax and can help reduce some income tax. But to say that you're going to have a trust and you're not going to pay any income taxes, run. Lies, lies, lies. Not true. And if somebody wants to fact check me on that, somebody wants to come on the show and prove me wrong, I'm here to say prove me wrong. I would love to hear it and love for you to teach me how you're doing that. And then we're going to have both of our legal counsel sitting here too, looking at the legal framework of what you're telling me you built out. But I'm calling you out there. If you've got a way to do that, I'd love to hear it. So if you're an attorney, CPA, to some person out there promoting that, I'd love to have you on the show and let's talk through that. So there you go. There's a challenge. So common types of trusts that can be used. So we've broken up a will, we've broken up a trust, specifically a revocable living trust. I love revocable living trusts because they're flexible, they avoid probate, and they're easy for common families to use. Irrevocable trust is a form of asset protection. Most of the time, when you see folks using irrevocable trust, they have a need or a desire to protect their estate from creditors and from legal disputes or lawsuits. There are certain types of trusts where we can do Medicaid planning. So Medicaid's a form of tax when you think about if you die in an estate where your assets have been sheltered from Medicaid, as an example. Those are called Medicaid trusts, and you'll have some attorneys design those to say, hey, we're going to put your assets in this special type of trust to avoid your estate being liquidated by Medicaid expenses. All that tells me is that you didn't do proper planning along the way and that your estate is now exposed to that risk called long-term care, and you're going to be in a position where you've got to have the state's insurance fund for long-term care, which is called Medicaid. And then you would be in a state-funded facility paid by other citizens, and you put your assets in a Medicaid trust to avoid the state coming back and taking your assets to pay the Medicaid bills. I'm not a big fan of that, and in estate planning and financial planning in my real profession, I would do everything I could to help you try to avoid that from happening or trying to set that in place. There are some attorneys out there who would do that, and I'm not sure that's a fair, righteous play for the rest of taxpayers, because really what you're doing in Medicaid planning now is you're saying, hey, all you other taxpayers who didn't utilize this tool, y'all pay for my Medicaid so that my trust can then avoid that, and I can give my kids up money that would have went for my medical care. I'm not going to get on my soapbox today, but I would say that sucks. For me personally, I would say that's kind of cheating, and I'm not a fan. But not to try to piss anyone off out there today, but kind of I don't care. Family protection. There are trusts that can provide family protection. A testamentary trust, which is created via will, and then the trust is activated after death. Not a fan of that, but there could be some instances where that's good. A minor's trust is basically going to hold assets for a child until they hit a certain age, and they'll be segregated and protected for that child. A spendthrift trust. This protects beneficiaries from creditors and poor financial decisions when they inherit money. So spendthrift basically means is that you're going to get your money segmented to you over time, not all in one lump sum. Inside a revocable living trust, attorneys and software like we use, we can give you spendthrift provisions that you can choose inside the trust for you to use to minimize the risk of your kids just blowing all the money at once. Special needs trust. I have a daughter who's 25 years old. She is incapacitated in some form. She's not able to make decisions on her own. We are now, at 25 years old, her conservator and guardian. And so in our family's revocable living trust, and my trust, Kathleen's trust, we have provisions in place that says a portion of our estate is going to be funded into Lizzie's special needs trust in the future. We're not doing it right now. It's kind of like testamentary, where after certain things happen, mainly the death of Kathleen and I, the second to die, a portion of our life insurance, a portion of our estate, is going to go for the benefit of our daughter who has special needs. And then we're going to have trustees assigned who will manage that. And it's basically my kids. I think my kids are well intended for their little sister and that they will do the right thing. And if they don't, we will come haunt the shit out of them at death. And Jacob, you're listening to this? And it won't be fun because I'll be standing over your bedside at night in ghostly chains and whips and all kinds of ghoulish stuff. But no, that special needs trust just says, hey, we're segregating a portion of our estate to take care of a person with special needs. When you get into tax planning, charity, and business planning, there are trusts that are called like creditor or credit shelter trusts, which is a way to help minimize estate tax. Generation skipping trusts, where you pass assets to grandchildren. So you'd skip the kids, go, kids, sorry, we like you, but if we could have known that we were going to have grandkids, we'd have had those first, so we're going to give them a generation skip. You don't get the money they do. That can be used a lot of times for parents who have adult children who might be struggling with some form of addiction. And you don't want to necessarily give them directly control of assets. You can use generation skipping trusts to make sure that the grandchildren are taken care of. And usually it's going to be a trustee that's not a child who may be dealing with some form of addiction. There's going to be trusts for charities. These are typically called charitable remainder trusts or charitable lead trusts. And it combines your philanthropic goals with tax benefits. Now, these types of trusts can help minimize income tax, but specifically designed for estate tax. But if you give money while you're living to an estate through, say, a charitable lead trust or charitable remainder trust, there can be some tax benefits there. Those can have some income tax benefits, but it's charity driven, not necessarily driven for you to have less tax so you can have more spending power. But those are available in rare circumstances for folks with significant estates. Then there's ILETs. ILET is an acronym for Irrevocable Life Insurance Trust. I use these often for folks who have estates, combined estates over $26 million, where we will fund their life insurance into an irrevocable life insurance trust, or we'll buy new life insurance and fund it into an irrevocable life insurance trust to segregate that from their estate so that it's not taxed at estate taxes. Life insurance is free from income tax in its beneficiary designation, so it bypasses probate. And if you have it inside trust and inside a irrevocable life insurance trust, it's going to avoid estate tax if you have an estate tax problem, if everything else is funded appropriately. So there's a lot of ifs and ands, and that's where you want to make sure in those type cases you do have a good legal counsel. Then there's business and voting trusts, and these are simply for corporations where maybe instead of me being a shareholder, I'm going to have my shares redirected to a business trust or to some voting trust where maybe I have a conflict of interest and I need to segregate that. A lot of times you'll see politicians do that, but for some odd reason it doesn't stop politicians from making bank on insider trading. Sidebar. Here's a kind of a trust decision tree. So, do you want to have control after death? A will or trust is needed. Do you want to avoid probate and keep your estate private? You're going to need a revocable living trust. Do you have minor children? A will, testamentary, or minor's trust would come into play there. Do you want to have control of timing, conditions of inheritance? Some form of trust, mainly a revocable living trust, can do the job. Let's say you have beneficiaries with disabilities. That's going to be a special needs trust. Are you concerned about long-term care costs? That could be irrevocable or Medicaid trusts, But again, I think if we're doing proper planning early enough, you don't have to spend the money or segregate a portion of your estate into those type trusts and kind of screw your neighbors. Estate tax. If you've got an estate tax, we need to have advanced trust planning. That's where we would recommend hiring an estate planning attorney to help you navigate through that. If you have basic needs and assets under 13 million or 26 million married filing jointly, more than likely you can do things in your estate with just a revocable living trust if there's no risk of your estate climbing above that estate planning or estate tax threshold. So charitable trusts or charitable goals, I should say, require charitable trusts. If you're going to give significant money now and after your death. And then life insurance or business coverage, we're going to use certain types of business trust or ILETs in those cases. So if any of those ring true for you today and you're like, I'm not sure which type of trust I should be using, somewhere in the comment section, we'll put a link to our calendar. And if you'd like to have a conversation with us about revocable living trust, we'll share with you our software as a service, Estate Box Pro. If you're a client of our firm with $250,000 or more of assets that we're managing or agent of, then there's significant discounts for that. If you're a veteran and you're listening as a veteran today, we provide significant discounts off that $1,995 price tag that you can get that for about a 35% discount. And we give you a code if you reach out to us. So let's think through some estate planning by the numbers as we close this out today. This is where you kind of got to self-identify for a minute. So 31% of Americans say that they have an executed will. 11% of Americans say that they have an executed and properly funded trust. But 55% say that they have no estate planning documents whatsoever. And then stats-wise, about 75% of Americans, when it's all said and done, according to state statistics, 75% of Americans are dying without a will. So what's interesting to me, if 31% of Americans say they have a will, there's probably some out there who didn't finish it, didn't complete it, or it was inaccurate. So it wasn't a valid will. But that's what got me, folks. 75% of Americans are dying without a will, which means your state, wherever you're at, is in charge. Don't let that happen to you. So interview questions when you're talking with an expert or talking with an attorney. Questions you need to ask is, what's going to happen when someone dies without a will? What makes a good executor or trustee? When someone really needs a trust, what's kind of the pro forma we would look at to do that? We did that earlier in the podcast to show you kind of the breakout. And then what document should every adult have? I would say this to you. You should have an executed will. That will should be a pour-over will if you have a revocable trust. But then you should also have individually, you and your spouse has a will. You and your spouse has medical directives and medical power of attorney and a limited power of attorney and what can happen before we start executing the will. And then there should be that will is called a pour-over will. And then there should be a revocable living trust that's properly funded, meaning your ownership has actually been changed from your real estate to your businesses to any non-IRA. So you can't change the title on an IRA or 401k to your trust. If you do, that triggers a taxable event because you're changing the ownership. But you can change the ownership of beneficiary designation. My recommendation with our clients internally, if you're a client of our firm, financial planning firm, we're going to say to you, Your primary beneficiary inside your 401k or your IRAs, from Roths to traditional IRAs, 401ks, TSPs, SARSEP Simples, any of those pre-tax accounts, primary beneficiary should be your spouse if the spouse is living. If it's not your spouse and you've got an adult responsible child, they could be your beneficiary, primary beneficiary. But primary should always be the spouse, in our opinion. If you're happy, if you love them, and you're in a great marriage, spouse. Contingent beneficiary could be the trust. But you want to make sure if you put the trust as a beneficiary of an IRA, there needs to be explicit instructions that that gets dispersed to those family members upon your death that you want that to go to, and they will inherit that through an inherited IRA based on how you want to split that out. Now, when a non-spouse inherits this IRA, they're going to have a different required minimum distribution than you and your spouse would have had. They're going to be required to distribute that IRA over 10 years on a 10-year schedule, and by the end of the 10th year, that IRA has to be at zero. You heard me right. Under Secure Act 2.0, any non-spouse inherited IRA by the end of the 10th year has to be at zero. And effectively, whatever the balance is, and the IRS was clear on this under 2.0, Secure Act 2.0, that you basically got to treat it like a 10-year distribution. So 1/10, 2/10, 3/10, by the time you get to the 10th year, whatever balance is left in that account, it's got to be liquidated out of the IRA. It can go to any other investment, but here's what they want: your tax. They want you to pay the federal and state tax on that. All right. So closing out today, think of it this way. Estate planning isn't about your money. It's about removing confusion and protecting the people you love. Hoping everything works out is not a plan. And I want to leave you with some folks who were well-intended, wealthy entertainers. And entertainers so often are just easy to pick on because they amass so much wealth and they get really busy in their careers and they don't do anything about their estate. They think, oh, well, I'll get to it later. Or maybe like a lot of us, I've heard folks say, well, Kenny, I feel like, man, if I do my will or if I buy some insurance, I'm afraid I'm going to die. Well, if you're afraid you're going to die, wouldn't you want to make sure that those are left behind have the easiest way to maintain and complete your estate wishes as if you were still there? So I'm going to pick on you a little bit. Quit being selfish. Do the right thing for you and your family so that the government doesn't get control. Your family keeps control. That's the bottom line. Prince, everybody knows Prince, or the artist formerly known as. He was one of my favorite singers. I got to see this guy in the late 1990s with a buddy of mine at the Norva in downtown Norfolk. Maybe there was 1,500 people in the audience, and I'm sitting right up front watching him basically play the Purple Rain album, and it was one of the coolest experiences, the most talented guy, musician-wise, that I think I've ever personally seen. Wrote all his own music, wrote his lyrics, could play multiple instruments, and not only play them, but master them, which was amazing. So Prince had an estate of $156 million, and we went out and Googled this a few weeks ago when we were talking about it. But he died without a will or a trust, and the estate was tied up in the court for years. And I think when it was all said and done, the state, the federal government, and the attorneys made more money than his heirs and his family. Guys, do y'all remember? I think this $156 million whittled down to like $85 million, and purportedly, allegedly, that those who were left behind, I think his sister specifically, if memory serves me right, do I remember reading that she ended up with less than $5 million? Can we pull that up? So this is the devastating part, that if he would have just had a revocable living trust at a minimum, he could have avoided probably at least 13 plus million in estate tax, and how it was exempted. The family wouldn't have battled over inheritance, and the public process of legal fees would have been far less. Are you guys finding that?
Yeah, we're looking it up. We're only finding how much his estate was worth when he died. 1 second.
Yeah, I remember reading in there when we were looking at this the other day that the sister ended up with some draconian, just gross amount compared to what his estate would have been worth and what she could have got, which is just really, really sad that people who were in no relationship with Prince won and everybody else lost. I talked about Aretha Franklin earlier. She had multiple handwritten wills stuffed in her couch and chairs, and she died with multiple valid handwritten wills. It confused the family and the court system, which led to legal disputes, which costs more money. So the key lesson is it's not about just having enough or having it put in place. It's about having a clear, legible, and accessible document that your families can know what your true meaning. Yeah, so tax impact, 40% federal tax rates plus
About 94
Minnesota.
million was left over.
Was it 94? I remember something about his sister not getting but a few $1 million. But anyways, the key factor in this is that the estate was diminished by poor planning. So Michael Jackson, again, one of my favorite all-time artists. When I go out to Vegas, I always try to go see the one show that he has out there, which is a lot of fun. That's kind of a tribute show now to him. Well, Michael had a trust. So his attorneys, his legal team put a trust together for him. Allegedly, Michael never funded the trust, meaning he never transitioned the ownership into his trust. And those assets went through probate. Everybody got more of the money than Michael's family, but it had created delays and additional costs, and it completely defeated the purpose of the trust by simply not being funded. Glenn Campbell. Campbell had a living death early on called Alzheimer's, and he was diagnosed in 2011. So what's crazy is because he didn't have clear executed plans, the family fought over his care and his money. And there were disputes about his guardianship and who would control and who would make decisions. And it was because his decisions were never clearly documented. The guys are fact-checking me in the back room here. Did you find some?
Yeah, I
some
was just
additional
going to say, going back to the Michael Jackson thing, and I'll pull it up now. So he had a $1 billion estate that went down to an inherited $10 million,
Oh my gosh,
which is just crazy.
that makes me sick to my stomach. That's insane. We were talking the other day, Jake. You know some weird facts about stuff. A million seconds.
Yeah. So yeah, 1 million seconds. Just gives perspective of how big these numbers are. 1 million seconds is about, I think, 13 days, 14 days, somewhere around there.
Yeah.
And 1 billion seconds is close to, or just over 30 years, I think, or maybe 20-something years, but still.
So you go from 1 billion to 10 million. If you think about the time value of money, that's just insane. The $990 million squandered because of not having a proper estate. That's just sad, folks. Don't let that happen to you is the key lesson here. Lastly, again, just one of my favorite actors in the Batman series was Heath Ledger. Who was y'all's favorite Batman?
Christian Bale.
Okay, I was going to say Christian Bale is probably right up there. Heath Ledger in the Batman series was an amazing actor, but unfortunately, he passed away at a very young age and died with an outdated will before his daughter's birth, and the entire estate went to the parents and sisters. Fortunately, the estate was passed on to his daughter voluntarily, but legally she was not included. So anytime you have a new baby, that means you're going to need to update your financial documents. You're going to need to update your beneficiary designations. And if you do nothing after listening to this today, at least go log into your investment accounts and check who's the beneficiary on your accounts. Are they still the people you want there as beneficiaries? Because if you have a named beneficiary, that actually bypasses probate, because it's now a legal channel of saying how you want your money to be passed on. But your estate without a trust, even if you have a will or intestate, the court still wants to know. They still want to be involved in that process. So we're really, really big fans of keeping your estate private through the use of revocable living trusts. Hey, hopefully today's info was valuable for you. And I just really wanted to spend some time producing this content and putting this out there for folks to start thinking about your estate. I mean, stats say there's overwhelming majority of Americans have no estate plan. And that's just something that's really easy to fix regardless of how much money you have. And it'll help you, I think, get you in the mindset for saying, well, man, if I'm going to go through the process of putting an estate in place, putting a will in place, maybe you'll start getting more serious about the rest of your finances and your money. Either way, we'd love to hear from you. I'd love to hear some comments back. If anybody's got any challenging comments for me that they want to challenge anything I said today, I'd love to hear from you. Maybe we'll bring you on the show and we can have a fun debate. But do me a favor, if you would, if this was good content for you today, hit that like button, subscribe. You can always unsubscribe, but at least subscribe to our show. We want to build our support, and we'd love to hear from you. We'd love to give you more content in the future. Hit that like button, hit that subscribe button, and we'll see you in a few days. Bye.
Blackbox.